No law older than the steam engine should decide who belongs in America tonight. Yet in March 2025, 137 Venezuelan men and women were taken from holding cells near Dulles Airport and flown out of the country under a statute written when George Washington still breathed. Picture the runway lights that evening, blue in the mist, as planes lifted toward El Salvador. Federal officers called it lawful duty. Judges called for restraint. The public called it confusion. Why would a president reach back to a 1798 War Act to chase a gang no nation had named? At dawn, in a courtroom on Constitution Avenue, Judge James Boasberg read the order that should have stopped those flights. The ink was barely dry when the jets cleared American air. By sunrise, the ACLU had filed J.G.G.V. The law in question, the Alien Enemies Act, once told presidents they could detain subjects of hostile nations. Now it was pointed at a criminal group. Could an old sword forged for war be swung in a time of fear? The case rose in haste to the Supreme Court. Picture the steps of that marble temple, April 7, 2025. 5 justices said challenges must come one person at a time, in the district of each arrest. 4 dissented, warning that power unreviewed soon grows wild. The question that echoed through those halls was simple, yet grave. What makes an enemy? An enemy, said the old statute, was a national foe in time of declared war. But no war had been declared, and Tren de Aragua flies no flag. The government answered, danger itself is war enough. Here the first thread of trouble tightens. Fear is quick to name new enemies, but law must be slower. The Constitution gives strength to the executive, yet places it inside bounds called due process. It is not only what a president may do that defines him, but what he refuses to do when others urge haste. Picture now the Federal Records Room in Washington, D.C., where clerks unbox the parchment of the 1798 Act. Edges brown with age, words written for battleships and muskets. The framers of that law feared invasion from France. They could not imagine jetliners carrying deportees. And yet, the statute still had force, so the courts struggled to decide whether its ancient language could stretch to fit a modern threat. One lawyer asked, if a gang is a nation, then who is left to be a criminal? The answer did not come that day. It came instead as silence from the bench, a silence that felt like warning. Because when definitions bend, rights break. From this confusion grows the deeper lesson. The rule of law is not tested in calm times, but in heated ones. When fear shouts, procedure whispers, and conscience listens. The cry of safety can drown out both. Think of wartime 1942, of the dark blot that was Korematsu versus United States, when citizens of Japanese birth were sent to camps while courts hesitated. In those days, officials swore they acted for defense. Years later, the nation apologized. What changed was not the law, it was the heart recalling its promise. I have seen what happens when power outruns patience. In my own war, I suspended habeas corpus where rebellion raged, but I faced Congress the moment peace allowed. I found no honor in unchecked command. The office does not belong to the man, it belongs to the law. Picture the D.C. courtroom months after those deportations. The same judge hears evidence that orders were disobeyed, flights hidden, records marked secret. The question before him is no longer immigration, but obedience itself. Can officers defy the court in the name of security and still claim fidelity to the Constitution? Power may argue that ends excuse means, yet republics die upon that notion. Each step that bypasses a hearing tells the people that rights are optional, but rights divorced from practice fade quicker than parchment. Now consider El Salvador, where those 137 are kept behind gray walls. Local guards hold a list with American seals. One man's name, cut into a wrist tag, belongs to a cook from Maracay who asked for asylum. He never saw the inside of a courtroom. His fate rests on whether our courts still reach across borders when freedom does not. Here rises the peak of our concern. If a person removed under our flag remains beyond our conscience, then justice ends at the shoreline. That cannot be the charter of a moral nation. Some argue that courts move too slowly for urgent peril. Yet the founders, men once under cannon fire, trusted in paper more than panic. They drafted procedures that forced the government to explain itself, because truth needs daylight. Think of Philadelphia in 1798. Congress met in the old brick hall near the river's bend. Two men from Virginia stood and warned against giving presidents limitless wartime reach. Others shouted them down, saying enemies lurked at the docks. The bill passed anyway. A century and more have tested their words, and still the argument returns dressed in modern fear. The present case is not only about migrants or even about a former president. It is about the ancient question: does safety need a master or a constitution? We might see strength in swift action, yet the truest strength is self-restraint inside office. Lawful authority must be daring enough to act, humble enough to answer. Where that balance holds, liberty endures. Where it fails, law becomes a mask for force. So picture again the marble steps of the Supreme Court, but this time empty at dusk. The flag above them has endured war, depression, and riot, because each branch bowed in turn to the limits written in that Constitution. The quiet stone there has heard anger before, yet it outlasted each storm because law, not passion, was given the final word. Picture the detention buses still parked at Lorton, Virginia. The numbered tags hang in their windows. Some seats will never be filled again. Those empty places are reminders. Every decision of power leaves human marks we cannot sand away. A free people must see those marks clearly, or they will repeat them with a steadier hand next time. When the founders divided power, it was not from mistrust of any one man. It was from full knowledge of mankind. They had fought a king and feared another rising in different form. So they placed ambition against ambition and conscience against command. That design remains the truest guard of liberty we possess. Yet the design only lives as long as citizens demand to see it honored. Courts can issue orders, presidents can rescind them, but the nation's moral shape rests in the eyes of those who watch and care. Without that watchfulness, parchment turns to dust. With it, the ink still breathes. Think again of those lights at Dulles Airport. In the weeks after the flights, reporters waited near the chain fence. Through the wire they filmed rows of empty transport planes under floodlight glare. Engines off, cargo doors open, nothing moving. That silence told more than speeches ever could. It said, "Power has spent itself, and judgment now begins." Such scenes are not new to history. Rome once claimed security as excuse for empire. France invoked order to smother its own revolution. Both learned that safety bought by silence invites a louder reckoning later. The United States was meant to prove another path, one where courage and caution walk together beneath law. That ideal has bent before, but not broken. It bent when fear interned innocence, when loyalty oaths burned reputations, when private letters were seized in the name of defense. Each time, years later, Americans looked back in shame and pledged restraint anew. Each time, their repentance made the nation more just than before. That is our recurring redemption. So the question that began with one mid-March night does not end with a court ruling or a headline. It lives wherever authority meets a soul it could crush, but chooses instead to hear. Every uniform, robe, and ballot carries that same trial. If you would keep a republic, you must guard not only your rights but also your patience. Patience for process, for debate, for appeal. The loudest voice may promise rescue, yet the steady hand delivers it. The safeguard of liberty lies in that slow, deliberate strength that refuses to trade conscience for speed. And because of that, I will tell you plainly, the Republic can be saved. It will be saved not by might alone, but by citizens who know the price of haste and the worth of law. When fear again tempts power to outrun justice, what will your answer be?